So today we are going to talk about earnest money. The forms specifically we'll be talking about are a little snippet of Form 21 because that's where the earnest money is kind of controlled. We'll be talking about Form 89, which not a lot of us use, but some of us may. And then the two forms to demand the earnest money, which are the Form 50 and 51. Also going to be talking about the difference between non-refundable deposits versus earnest money and kind of some scenarios we may find ourselves in, especially coming out of the market that we've come out of. So what I'd like to kind of keep in mind while we're going through these things are, why do we collect earnest money? What happens if it's late or it never gets deposited? How can we make demands for the earnest money when the contract or if the contract is terminated, and who gets it? Also, consequences surrounding the idea of the non-refundable deposit. So those are all points I'm going to touch on in these slides. And if any of these questions don't get completely answered, we can definitely talk about them at the end. So first, why do we need earnest money, and what are some things we need to know when we're filling these things out? Well, earnest money is essentially a pre-agreed settlement in the event of a buyer breach. So we're pre-deciding at the beginning of the contract what's going to happen if the buyer doesn't follow through with their end of the deal. So in our purchase and sale agreement, we have line 7 being the earnest money and line 8 being the result of what happens in that breach. Now, for our earnest money itself, there's no real right answer when it comes to how much earnest money we can put in there. It's all going to depend on the contingencies that are in the contract, the closing time. It's just going to be dependent on each contract individually. We want to make sure that we are writing the date that we want this earnest money delivered. The delivery date that we write here is the date that it is actually deposited in the account that it's going to. Is it going to go to the closing agent? Is it going to be held by the other firm? Wherever it goes, it needs to be there, deposited, check cleared by the date of delivery. And then number 8, in the event that there is a default, it's the predetermined what's going to happen. So the forfeiture of earnest money just basically tells that seller, hey, buyer, if you breach, the remedy for you is, seller, if the buyer breaches, the remedy for you is going to be this money that they've put up front. And then seller's election of remedies does give sort of a broader view of maybe some things that seller could come back with besides just earnest money. So I'm also going to talk about what happens if the money is received or not. Now, putting the money on here, putting the earnest money amount in this section is an obligation that the buyer has. Now, that them not depositing the earnest money doesn't remove any responsibilities. It still is a requirement for the buyer to give seller if there is a breach, whether the money is actually gone in there or not. But keeping that in mind in the back of our heads, what happens if the earnest money is not delivered on time? Well, that gives basically that seller this sort of extra right. So buyer didn't do what they said they would do. Seller actually does have the right to kick that buyer out and move on to someone else that they feel may be more qualified. So if there is a late deposit of earnest money, we are not going to be writing up an addendum to excuse that breach from the buyer, but rather we're going to turn back to the seller and give the seller the right to do as they choose. Do they want to terminate? Do they want to move forward and still require that deposit to be made? So with these boxes here, sometimes there's a lot going on Form 21, and sometimes these little check boxes get missed. Missing any of these boxes does not mean that contract is not mutual. So there is actually a default for both lines 7 and 8. Earnest money default will default the number of days in the boilerplate language on 21. And the default will also, for the default line 8, it will also have a default for the default, also in Form 21. So paragraph B actually just says, if it's not filled in, the earnest money is due 2 days after mutual acceptance. So if that line is ever blank, keep in mind that your timeline is 2 days after mutual acceptance, and that's the date that it has to be cleared and deposited into the closing agent or escrow, or the holding firm, whatever is decided on that page. And as far as the damages, it will default to the seller's election of remedies if you don't check the forfeiture of earnest money. Washington State gives the seller the upper hand when it comes to a buyer default as per our law. So if you want something very specific, as in you only get the opportunity to get earnest money, make sure you are checking the forfeiture of earnest money for line 8. Okay, so what happens if you receive earnest money? We don't typically do that. It's not ideal. Ideally, we want escrow to take that money directly. We don't want to touch it. But if we happen to receive an earnest money check, we definitely do need to document everything. We are responsible for making sure that all monies are accounted for. It's part of our agency law. It's part of our requirements in our business. So what we want to do is reach for Form 89, which is an earnest money receipt. If you receive a paper check, make sure you're making a photocopy of the check. In that photocopy, you can go ahead and redact the account number, but do keep that copy. And if you do happen to hold on to the check, please reach out to Jason or Joe and find out where we can secure that money until escrow opens. Once escrow is open, it would be delivered immediately to escrow. So if you're holding on to that check during business hours, make sure you're driving it straight over to where it needs to be. If necessary, like I said, put it in a secure place. Again, reach out to Jason or Joe to find out where that secured place may be. But again, ideally, we want escrow to be the ones handling earnest money. So late earnest money, what happens? What should we be doing here? Do we need an addendum for late earnest money? And what happens if it's late, or what if the check bounces? So as I kind of mentioned before, we do not need an addendum to extend that buyer's timeline to turn in the earnest money. All it does is give the power back to the seller for them to decide if they want to bump that buyer out of the way, or if they want to just keep waiting for that check to come in. Let's not take the power out of our seller's hands because the buyer didn't deposit the money on time. If the check happens to bounce, or if it doesn't get deposited, escrow will be contacting all parties and notifying everybody that this happened. If it didn't clear, this means the money is going to have to be deposited into escrow in a different way. If they write a check and the check bounces, it's very unlikely that escrow company will accept a second check. So what should the buyer do in this situation? Well, if you have the buyer who has either a bounced check, forgot to deposit the money, or for some reason made it late, I would reach out to them immediately and see if they can get a different deposit, or somehow get that money into escrow as soon as possible. And sellers, if they choose, they can terminate or just wait for it to come in. So in the event of an earnest money dispute, which I'm not going to go over in too much detail because I have in a later class terminations, but if there is a termination and you need to instruct escrow to release earnest money or give instructions, or even if there is a disagreement on where the money should go, that process is outlined in paragraph B. This is the second half of paragraph B on Form 21. It just tells the timelines that escrow has to get all the paperwork together. It outlines what you should be expecting. I know the interpleader amount has gone up from 500 to 750, but again, in a different class on terminations, we'll go over this in more detail. The important thing to know is that if you are terminating and you need to demand earnest money from escrow, you should do it immediately. And the escrow resolution of where that money is going does need to be done within 20 days. Okay, so Form 50. Basically, every instruction that we give escrow is going to be coming from one of our statewide forms. And Form 50 is just a way for us to tell escrow what to do with this money. If you need to demand this earnest money, say there's no dispute on this. This is just about, maybe an inspection contingency, keeping it simple. We do still need to not only terminate the contract, but also tell escrow to release that earnest money and then tell them where it's going. So by making the demand, you fill out the Form 50. This is just a disbursement of earnest money. It tells where the earnest money is going to go to. It notifies escrow that one party has made the demand, and once that demand is made, again, it starts this escrow clock of needing to pay out that earnest money within a certain time frame. Escrow will disperse to the party making the demand unless there is an objection, although they do need to also have an absolute agreement by the end of their 20 days. So make sure if your client is the one demanding the earnest money that you get this form in as quickly as possible, hopefully working out all the kinks before the 20 days is over. I've seen the use of Form 51 as well. And I wanted to bring it up mainly because it does look really, really similar, but there's a difference in the forms between the 50 and the 51. The 50 is a form that is meant for specifically telling escrow, this is to disperse earnest money. It is to be used with another termination. This is not a termination in itself. The 50 is just the instructions on what to do with the money. A 51 is a rescission agreement. So this is the termination, and in that termination, it tells them what to do with the money as well. This is going to be used when your buyer has no contractual out. So they've gone through all their contingencies and maybe mutually just decided this isn't going to work. Seller agrees to allow the buyer out, buyer wants out, and everybody signs this form and they're happy. If you have any other out for that buyer, if you are using any contingency right, make sure this is not the form that you turn in to terminate your contract. Non-refundable deposits. So this has been happening, and there can be a time and a place where this works. So think about what a non-refundable deposit is. First of all, if we are taking money that is not being used for damages and to be used for something else, then it is no longer earnest money. So if that is the case, then the term non-refundable deposit really should be used, because earnest money is the award of damages. Non-refundable deposit has a completely different meaning. With builders, it means, you pay this money for this upgrade and, who knows what happens after that. But in a normal purchase and sale agreement, you don't have that situation. So when we're using things like non-refundable deposits, what we're saying, in fact, is that we're giving the seller part of their earnest money in advance. But hey, by the way, some of it goes to the purchase price. But when you're doing this, keep in mind there's going to be a potential conflict if you have any contingencies left in place. If you are handing over part of the earnest money and you still have a financing contingency, then that buyer still has the financing out. So what's going to happen when that seller is holding on to $5,000, that they may have already spent thinking the sale is going to close, and your buyer actually does have a contingency out. We do have a John L. Scott non-refundable fee addendum. It is essentially the same thing as a Form 50. So the form with the John L. Scott has really, really great verbiage down below that basically just says, you know, this portion of the earnest money is going to be non-refundable. It's going to go to the closing agent. It's going to be part of the purchase price. Basically, the buyer's not going to lose this money. We're just prepaying it in advance, but seller, you're not allowed to breach the sale just to keep the money. So it has that really great verbiage down below. On the right-hand side, the disbursement for earnest money does instruct escrow on where to put it. So essentially, it's the same instruction. And using the one on the right keeps the rest of the verbiage from the contract too, that also does not allow seller breach to benefit a seller. But again, when it comes to contingency outs, make sure that if you're releasing earnest money in any capacity, that there's no room for a conflict of having that buyer get the right to that money back. If this is the case and you represent a seller who wants this earnest money, released, I would highly suggest telling them to keep it in escrow for now, not spending it, because if that buyer has a way out and a right to do so, there will be a fight over where this money is going to come back from. And I would hate to see an agent have to bring that out of their own pocket because they didn't realize there was a conflict of contract terms. So there are pitfalls, like I said, to non-refundable deposits. We have conflicting contingencies. What happens if the seller breaches? If the seller is, collects their $10,000 of non-refundable money and then they're, maybe bad faith, good faith, I don't know. Just keep in mind, we have to keep to the facts. As agents, we are only looking at the contract itself. So when we look at it, we need to follow what contingencies are connected to what. And as far as the decision of good faith or bad faith, that is far beyond our scope, and we are not allowed to make that decision. So if you have somebody wanting a non-refundable deposit, the best thing I can suggest is to make sure the buyer has waived all contingencies. If you are ever in question of the buyer having waived contingencies, you can put on a Form 34, buyer waives all contingencies. And that will blanket statement, waive the contingencies in the contract, and keep you moving forward. It's a really gray area though, so just be careful doing something with the non-refundables. So when talking about earnest money, a lot of times we have conversations with not only the buyers, but also the sellers of how much is enough. If we're looking at $1 million home, and they want to put a $5,000 earnest money deposit down, is that enough? So the enough part is a conversation that you should be having based on the contracts that you have put in front of you. It should be dependent on the contingencies that you have, maybe the closing date. How much risk is that seller taking to accept this offer versus, risk versus reward? If the property is only off the market for a week, is it worth $5,000? Possibly. We were having these big increases in our values, or big decreases even, when we had the downturn and the falling house numbers in 2008, 2009, sellers were putting their homes under contract for earnest money, and a buyer would walk away. That seller would lose thousands of dollars being off the market, having to readjust to wherever that market was crashing at the time. So this earnest money has to be thought of in all ways. Another thing we want to talk about is who gets the earnest money when it's terminated. And how much can the buyer lose at one time? Oops, sorry. If we check boxes, basically in Washington state, we have a law that says that the damages in our contracts cannot exceed 5%. So if we check the seller remedy box, it's 5%. If we check the forfeiture of earnest money, it's 5%. The difference in what we're going to do with those two boxes will depend on what else the seller wants to ask for. Anything additional beyond the 5%, you should probably have some sort of an attorney draft up what those seller damages are. Now, we're not saying the seller doesn't have the right to ask for those damages, because if you check seller's election of remedies, you're giving that seller that option right up in the beginning to go ahead and possibly, reach for other things, performance. Maybe you want them to have to buy the house. Maybe that seller needs to be reimbursed for something huge that happened. So we can get more than 5%, but per our real estate contract, we are kind of capped at 5%, unless there's other verbiage written, preferably by an attorney, that allows that seller to receive more than just their 5% or other remedies beyond money. So if you're terminating and you need to request this earnest money, we are going to be sending escrow the earnest money disbursement form. We have to give escrow instructions on all this. They should not be releasing this earnest money until they've received something like this. Oops, sorry. So Form 50 is what we want to do to give escrow the instructions. Now, if we have a huge amount, escrow doesn't go back and calculate 5%. They are simply following the instructions we give them. So no dispute should happen with escrow and 5% or more than 5% when it comes to earnest money retention. That's a dispute that we need to handle on our side. They're just going to be doing the instructions that they've been given. But also keep in mind, we do need to have a resolution for escrow on what to do with that earnest money. And if we do not, we will be needing to take it further. It will be costing people money. I hope nobody's ever got there. So one of the biggest pieces of our contracts and our files that get audited are proof of this earnest money going in. So ways to protect you if in the event you get audited and we need to prove things. So the first thing you need to make sure you have in all your brokerment files is the proof of the timely delivery for the earnest money. We can get this by an email from escrow. We can have a handwritten receipt from escrow. It doesn't matter. We need proof of the delivery of the earnest money to escrow. We also need to prove that we're communicating to sellers if the earnest money has been deposited late. Now, if you get a notification from escrow that it hasn't been deposited, or if you are proactive and finding out that it has not been deposited on time, make sure that you're sending your seller an email notifying them that the earnest money has not been deposited, and also in that same email letting them know their choices as a seller to either terminate or wait. Make sure that you're also CCing either the firm or somehow getting this into your brokerment file for later. As sellers, we want to make sure we are advising them if the earnest money is late. We, as buyers, also want to be advising them of the risks they're taking by not having this deposited in time. So they are risking potentially getting kicked out of their contract. They're also risking, well, that's about all they're risking, but it does not excuse them from the rest of their obligations. So they cannot breach contract just because they didn't deposit the earnest money. As buyers, we want to tell them how they can cure this. they can cure it by depositing the money into the escrow account. We do not, though, want to write up an addendum just to cure this breach. We just want to tell the parties their rights since this has happened. Okay, so another thing I wanted to say is, why do we do earnest money? And what happens if somebody wants to do $0 in earnest money? Thinking about what it means and curing breaches and giving seller remedies for breaches. If you find yourself in a situation where there are contingencies, but a buyer wants to put in $0 in earnest money, you may want to have them consider why they have contingencies to begin with, because earnest money is the seller remedy in the result of breaching those without the protection of the contingencies. So basically what I want to get out of this too is that there should be some sort of dollar amount that we're putting into this for our sellers. And as agents, when it comes to our standard of care, we're going to be held pretty high when it comes to this. We have to prove that we are tracking financially where the money is going. And we need to make sure that we are not going to get ourselves into this situation of conflicting contract terms. So if you find yourself in a way, I'm going to pull myself back up to the screen. If you find yourself in a place where you're faced with a non-refundable deposit, please do your best to make sure that when you accept this term, that there's nothing else that conflicts with it. There have actually been cases that I couldn't quite attach to this slide, but there have been cases where agents have been faulted because they were seen as not having the standard of care that they should have by drafting up conflicting terms and contracts. This is just one of those conflicting terms that we could be potentially getting ourselves into, having this non-refundable, but yet protections for refundable. And then for my last sort of lead into terminations, keep in mind that when you have some sort of termination, so say the financing contingency, we all think, oh, this buyer has so many rights under these contingencies and buyers just have the leg up. There's always going to be the burden of proof for that buyer to get out on a contingency like that. So for example, if you have the 22A, the buyer doesn't just get the earnest money. The buyer has to prove that they've done the things needed to be done in order to have the protection for their contingency. We need to also make sure that we're not judging our earnest money disputes on good faith or bad faith. So if you do find yourself in a situation like that, please feel free to reach out and we'll talk over what contingencies that buyer has and what they could possibly be terminating for.